Commissioner of Customs and District Collector of the Port of Subic versus Hypermix Feeds Corporation. GR number 179579, February 1, 2012. Facts. On November 7, 2003, Petitioner Commissioner of Customs issued Customs Memorandum Order, or CMO, 272003. Under the memorandum, for tariff purposes, wheat is to be classified according to number 1, importer or consignee, number 2, country of origin, and 3, port of discharge. Depending on these factors, wheat would be classified as either food grade or food feed. The corresponding tariff for food grade wheat was 3%, and for food feed grade, 7%. A month after the issuance of CMO 272003, respondent filed a petition for declaratory relief with the Regional Trial Court of Las Piñas City. Respondent contended that CMO 272003 was issued without following the mandate of the revised Administrative Code on public participation, prior notice, and publication or registration with the University of the Philippines Law Center. Respondent also alleged that the regulation summarily adjudged it to be a food feed grade supplier without the benefit of prior assessment and examination, and despite having imported food grade wheat, it would be subjected to the 7% tariff upon the arrival of the shipment, forcing it to pay 133%. Respondent also claimed that the Equal Protection Clause of the Constitution was violated and asserted that the retroactive application of the regulation was confiscatory in nature. Petitioners filed a motion to dismiss. They alleged that number 1, the RTC did not have jurisdiction over the subject matter of the case. Number 2, an action for declaratory relief was improper. Number 3, CMO 272003 was internal administrative rule, not legislative in nature. And number 4, the claims of respondent were speculative and premature because the Bureau of Customs had yet to examine respondent's products. RTC held that the petition for declaratory relief was proper remedy and that the respondent was a proper party to file it. Issues. Whether or not the CMO 272003 of the petitioner met the requirements for the revised Administrative Code. Held. No. The petitioners violated respondents' right to due process in the issuance of CMO 272003 when they failed to observe the requirements under the Administrative Code, which are Section 3, Filing. Every agency shall file with the University of the Philippines Law Center 3 certified copies of every rule adopted by it. And Section 9, Public Participation. If not otherwise required by law, an agency shall, as far as practicable, publish and circulate notices of proposed rules and afford interested parties the opportunities to submit their views prior to adoption of any rule. Issue number 2. Whether or not the content of the CMO 272003 met the requirement of the Equal Protection Clause of the Constitution. Held. No. CMO 272003 did not meet these requirements. For a classification to be reasonable, it must be shown that number 1, it rests on substantial distinctions. Number 2, it is germane to the purpose of the law. Number 3, it is not limited to existing conditions only. And number 4, it applies equally to all members of the same class. Petitioners violated respondents' right to equal protection of laws when they provided for unreasonable classification in the application of the regulation. Petitioner Commissioner of Customs went beyond his powers of delegated authority when the regulation limited the powers of the customs officer to examine and assess imported articles.